Good afternoon. I'm Robert Falkenberg. I am the presiding associate judge for the Child Protection Court of South Texas, and I'm here today to explain to you why the court has a YouTube channel and how we are using that to respond to the current pandemic. As we all know, COVID-19 has resulted in a global pandemic, and the Supreme Court of Texas and the Court of Criminal Appeals have issued emergency orders, and under direction of the Office of Court Administration, the Child Protection Court of South Texas will hold all hearings and trials remotely until at least May 8th, 2020. And to do so, we're going to use the Zoom video telephone conferencing application to have our hearings and trials. The attorneys, the parties, the court-appointed special advocates, and witnesses will use the Zoom application on their computers and phones.
Okay, welcome to the 336 District Court. My name is Lori Blake and I serve as the judge in this court. Today we are testing our live streaming capability on the court's YouTube channel. The purpose of the YouTube channel is to provide public access and open court to the 336 District Court proceedings instead of personal appearances in the courtroom. The Governor of the State of Texas, as well as the Texas Supreme Court and the Texas Court of Criminal Appeals, have orders in place to ensure that trial courts like the 336 District Court continue to
and give their attention. The court is now sitting. God save the state of Texas in this honorable court.
Good morning. The COVID-19 pandemic has required many adjustments of the justice system. Social distancing and group size restrictions, as well as potential hardships on counsel or travel to Austin, do not allow us to hold argument in the courtroom. Rather than submit cases without argument, we've decided to proceed through remote connections. Court staff has made every effort to prepare us and counsel, but of course there may be glitches which will require patience. Otherwise, we will proceed in the same manner as we would in person. The arguments are being live streamed this morning, and a recording will be available later in the day. We're ready to hear argument in 18.
I have to say that almost every term. But in addition, the Enterprise case says that if somebody's going to argue waiver by conduct, they're required to either obtain a jury finding on waiver or to prove it conclusively. So what conduct is there here that conclusively proves waiver, that the parties knowingly agreed to change this operation? W&T points to the fact that he was under their direction and control. We already talked about that. It's disputed. There's a fact issue on that. They say that he slept with them and ate with them. And that whole time he was wearing a W&T uniform. He was receiving W&T benefit in his paycheck, as well as benefits, and no, he never was treated by anybody as an employee of W&T. So while the courts say that contract language can be waived by conduct, what's the conduct here that waived it? Certainly in light of the contract provision that says that it has to be done in writing. So I think that the language of the Court of Appeals was put this best.
Any other questions? Thank you, Mr. Wright. Case is submitted, and the court will take a brief recess. Thank you
very much.
Mm-hmm.